table there where you for Miss Lambert, if you didn't already pick one up. And also please remember to keep your voices down during the presentation to be respectful to our colleagues and our speaker. Our flower pot fund this year is volunteer legal services. There are flower pots that you can drop cash and change into, or if you prefer, there's also QR codes on each one of those. And now Ms. Hannah is going to introduce Ms. Amy Lambert.
Hello, y'all. My name is Hannah, and I am Amy's paralegal. I just wanted to introduce y'all to Amy. Amy got her undergraduate degree at the University of Texas and her doctorate of jurisprudence at Texas Tech Law School. She was admitted to the bar in 2006 and became an associate at the law offices of Jennifer Tull. She made partner in 2012 and they became Tull and Lambert. In 2014, she established a new firm with Jonathan Friday, Scott Milner, Jamie Turner, where they all still remain as partners today. Friday, Milner, Lambert, Turner, commonly known as FMLT, is a family law firm. Each partner has their own niche practice of the area of family law. Amy specializes in collaborative divorce law, mediation, prenup and postnuptial agreements, alternative dispute resolution, and estate planning. She has served as the chair and director of the family law section of the Austin Bar Association and has served on the State Bar of Texas Grievance Committee. She has authored articles and given presentations for various organizations and served as the course director for the State Bar of Texas. She is the vice president and president-elect of the Collaborative Divorce Austin. She is an active member of Collaborative Divorce Texas and is on the board of trustees. She serves on the board for Volunteer Legal Services of Austin and at Austin New Church. Most importantly, she is an amazing mother, wife, community member, and friend. She is one of my favorite humans and somebody that I'm proud to call a boss as well as my friend, Amy Lambert.
Want to give a shout out about your upcoming chili cook-off and make sure everybody knows about it?
For sure. Thank you, Hannah. And thank you, Amber, for inviting me, and thank all of y'all. So as Amber was saying, at Friday Milner Lambert Turner, we host an annual chili cook-off every year. It's on December 10th at our office. If you want to be invited, just get Amber your email and she'll get them to me and we'll add it. It's a fundraiser for Volunteer Legal Services of Central Texas. And last year we raised over $88,000 for them. And so it is a big deal. It's a lot of fun. You don't have to eat chili. You can taste chili if you want. We invite different family law firms to come compete and they cook the chili, and then a bunch of people bring pies, and we have a pie contest too. And the local judges are our judges. And so you get to meet judges, meet family lawyers, if that's your boat. And we'd love to have you guys there. Thank you all for having me. As Hannah mentioned, I'm a family lawyer. And so today we're going to be talking about premarital and postmarital agreements. And I've put a handout for you guys. I'll email the documents to Amber so she can send them to you digitally as well. Some of them are forms in case you want to use them. I'm always a big sharer of my, so any time you ever have a question about drafting or anything in this subject matter, do not hesitate to reach out to me or Hannah because I am a form sharer. So first of all, let's get out of the way some vocabulary lessons. We're going to use premarital and postmarital agreements today as our terms, but also, or prenup or postnup is probably what I'll use. Premarital agreement is the same thing as a prenup, and a postnup in Texas is called a partition or exchange agreement. That is not a natural thing that rolls out of your brain typically for people talking about this, so I'm not going to really use that term. All of them are called marital property. So most of what we're going to talk about today applies to both prenups and postnups. And so I'm just going to refer to them as that or marital property. I have been doing this type of practice for about 15, 16 years. And I've seen a trend change over this time period. When I first got into this practice, the only folks that were getting prenups or postnups were people that one side had a bunch of family money and their parents wanted them to have a prenup or a postnup if they were a young couple. Or the second common category we saw was one party was a really moneyed spouse and the other party had nothing, and the moneyed spouse did not want the spouse that had nothing to take any of their money if they got divorced. And then the third category of folks we saw a lot were couples who were getting married for the second or maybe the third time and had older children or children from their first relationship or prior relationship, and they wanted to protect their estate for those folks. These agreements weren't done on the regular back then. That has changed. We do these all the time now. I mean, I was looking at my calendar just to see how many I'd done in the last month or so. I had 3 consults for them last Thursday. So, I mean, we're doing them a lot. And there's a couple reasons for that, I think. Number one, I think we are now at a generation of folks getting married whose parents went through divorce and they want to avoid conflict and a lot of difficulty. And so I'm doing a ton of these agreements for folks who are young on their first marriage, maybe don't have a ton of assets, but just want to simplify things and make a clean path forward when and if they end up getting divorced. I'm also seeing a lot of folks who just want to keep their finances separate, and that's just how they want to live. The thing that I tell people is everybody who gets married, you have a premarital agreement. If you get divorced, you have a premarital agreement, and it has been created by the legislature in the state in which you're divorced. So the question really is, do you want to create your own rules and arrangements, or do you want to allow a bunch of strangers, and in Texas, a bunch of, old white men to create the rules for you? So a lot of folks do premarital agreements just to kind of set their own rules. We typically see a spectrum. One end of the spectrum is we're just going to paper the law and we're going to write down exactly what the law says essentially, but we're going to maybe make a couple things really clear so there's not much to argue over in the event that we get divorced. The other end of the spectrum is we're going to keep everything separate. All the income from our separate property is going to stay separate. All our income from our employment is going to stay separate. And we may set up another few rules as well. And then in the middle is infinite different options and combinations of both of those. And I have had a few clients who, came out here and created their own marital property scheme for if they get divorced, this is what the law is going to be. I don't recommend that because that's going to be foreign to whatever judge or arbitrator is interpreting the document in the event they get divorced. But some people insist, and so they that's what they choose. So let's talk a little bit about marital property in Texas, just so you guys kind of have the lay of it. This is set out in my handout, but you don't need to look at it to listen to this. But Texas is a community property state. And what that means is at the time of a spouse's death or divorce, everything owned by both spouses is presumed to be community property, okay? You can show that something is somebody's separate property and it gets pulled out of the pot and set aside to them if you can show that it was owned prior to the marriage, that it was received by inheritance, received by a gift, or received by a personal injury award, or originated from any one of those 4 methods and has now been transmutated into some other type of asset. If you're going to be showing that it is separate property, you have to prove that by clear and convincing evidence. So y'all may remember that, there's several burdens of proof. There's preponderance of the evidence, which is just a little bit more than 50-50. That's this burden in civil law. And then there's beyond a reasonable doubt that is the burden in criminal law. Somewhere in here, and nobody knows exactly where, is clear and convincing evidence. So it's less than beyond a reasonable doubt, but more than a preponderance of the evidence. And Texas, that means that if it's an asset, you have to prove with really good evidence that it's separate property to get it pulled out of the pot. With real estate or a titled asset like a car, that's easy. You can just show the title and when it originated. And if it originated before the marriage, that's really clear. If it's a financial account, retirement, whatever, it can be a lot harder. And clear and convincing evidence our Court of Appeals has held is a very, very detailed tracing showing where every penny was from the, month prior to the marriage to the time of divorce. Now, it gets even murkier and trickier because in Texas, income off separate property is community property. So if you have a retirement account, and I have clients come to me all the time when they're getting divorced, they're like, I had a retirement account pre-marriage, I haven't touched it, don't worry, it's my separate property. And I'm like, oh no, friends, we've got a mess. Because almost always, and especially if anybody's been married for more than a couple of years, all the investment accounts kick off interest, dividends, income. 9 times out of 10, 99 times out of 100, those are getting reinvested into that account. And it's getting the magic term commingled. Now, you can pull things apart by doing a tracing and clear and convincing evidence. If they've been married for less than 10 years, these days, it's pretty easy to do because most financial institutions keep their records for at least 7, if not 10 years. Charles Schwab is my favorite, has been keeping theirs pretty much since about the early 1980s. So if you have Charles Schwab, you can pretty much always get your records. A lot of the other financial institutions, you can't get it. And if you can't get the records and you can't make that clear and convincing evidence and prove that, you're out of luck and boom, whatever you acquired in that account prior to the marriage ends up typically becoming community. So to avoid that, a lot of times folks will set up premarital agreements and agree, among many other things, that the income from their separate property is going to be separate property instead of community. And so that's a very common hybrid that I do that people elect, which is to say that income off all of parties' pre-marriage assets is going to remain separate, but income during the marriage is going to remain community, and income from the salary during the marriage is going to remain community. And so that's a common hybrid that people like to choose because as long as they don't move their stuff around, then typically they don't have to do the tracing to prove all of that because everything that stays in that account that's set out in the schedule of the premarital agreement can be set aside. So let's talk a little bit about what's required for a premarital or postmarital agreement in Texas. The Family Code Statute 4.001 is what sets out the terms, and it has to be a written agreement that's signed by both parties. It's enforceable without consideration. So it can be really draconian and favor one side completely, and that's okay as long as it's signed by both parties. Those are the 2 requirements, but the agreement can be found to be unenforceable if a couple things are proved. Number 1, that one of the parties did not sign it voluntarily. And that's a pretty hard thing to prove. You have to typically have evidence from other folks at the time. This other problem that I'm going to talk about is what we see more commonly, but even then, Texas is very in favor of premarital and postmarital agreements. So it is rare that they are undone. But if the agreement was unconscionable when it was signed, number 1, that's prong A, and the party that's complaining that it needs to be opened up was not provided a fair and a reasonable disclosure of the financial obligations and assets of the other party, they did not sign a waiver, waiving their right to that information, and they couldn't have known that information otherwise. So it has to hit all 3 of those and be unconscionable at the time of signing. Any family lawyer who does this regularly and frequently is going to make sure those prongs are not there. I personally have every single client when they're and their spouse are signing, I have them sign the waiver of financial, we do a disclosure of all the financial information. Then we sign a waiver of further disclosure of financial information. Then we sign a premarital. I also typically, and this has been a newer trend that I've been doing, have a court reporter present. and I have a court reporter take a transcript of the, of what the testimony that I ask each side to give when we're signing it, to hit all the elements and make sure that we're covering every single one of those bases, including the voluntariness and the unconscionability, and do they know all the assets and liabilities? And what does that run in? About $300, $400 cost wise? It is not expensive when you talk about the level of protection that it provides for your client. I mean, from a cost benefit analysis, it's a no-brainer. I wish I'd been doing it since the beginning of time.
Can I ask a question?
Absolutely, and I invite questions while we're going, so how about it?
What, I know, I don't know, what is unconscionable?
What is unconscionable? Okay, so if it was unconscionable that spouse A had billions of dollars and spouse B had nothing, but it could only be unconscionable if spouse B received no disclosure of assets, knew nothing about the business, about their value, did not sign a waiver saying that they waived that information, and C had no other way of knowing, like this person was worth billions of dollars, but they're living in a shack or something like that, right? So it's very, very rare that those elements are hit. And typically the only times I have even read about, I've never seen that in any of my cases, and certainly even any cases that we've tried in our firm, because we do a fair amount of premarital agreement defense. But the only time I've ever even heard of those types of things happening is when somebody got like a document off LegalZoom or wrote it up themselves, you know? Clients think, as you guys all know, they think a lot of times they know better than a lawyer. Why pay a lawyer when you can go on LegalZoom and do it? I don't know if you guys know who Russell Simmons is. He's a famous music producer.
Yeah.
And there's a famous prenup story with him that in a moment of passion with his wife one night, he's like, baby, I love you. We're getting rid of our prenup. And he tore it up in front of her and burned it in the fire. Well, guess what? That doesn't terminate a prenup. The only way to terminate it is to sign a new document that says it's terminated, kind of like a will. And so later, when they got divorced, he said, you know, just kidding. I didn't really mean that. So, and the court upheld that they were going to go by, their divorce was going to go by their prenup. So tearing it up in a fit of passion doesn't do anything. So let's talk a little, any other questions before I go into kind of what can be in a prenup and what can't? Yes.
How do your consults if you have like, you know, one side, like, I want to do a prenup, my partner wants to come into the office too, like, do you make sure that they have another attorney representing them or?
Absolutely. So I do not meet with both sides. I refuse to do it. I will not do it. If they insist on that, I'm like, good luck down the road. That's not going to be me. That's going to put, you know, my bar license on the line. I would say about 60 to 70% both sides have lawyers, and about 30% one side chooses not to get a lawyer. Yes, Chris. Okay. The document's written in pretty plain language. Obviously, there's the concepts of community property and separate property, and those can be really confusing to a layperson. But it is not unusual for one side not to get a lawyer. Now, my philosophy towards premarital agreements is not to do an arm wrestle and stand on the lesser money spouse's neck. I am not into that. I don't believe in that. I believe that this document should be used to create a better foundation of understanding between the parties for their finances, for their future of their marriage. In the olden days, it was not unusual for us to see premarital agreements from estate planners that were really draconian and basically gave the moneyed spouse everything and then not moneyed spouse nothing. My preferred way of operating is to not draft up the agreement. It's to talk to my client, get another lawyer on the other side representing the spouse. The four of us sit down together, talk about what everybody's goals are, and come up with a document and an agreement that meets both parties' goals, not just one party's goals. Because, you know, so many people start down the path of marriage not having discussions about finances and what things are gonna look like. And so I see this as just another opportunity where we can build a stronger foundation for them. So I have a list of lawyers that I work with frequently that all take the same approach that I do. And, there's a lot of them. And so I usually will send that list of lawyers to my client to share with their fiance so that we can start that discussion. Now, sometimes they don't want to get a lawyer. Sometimes they come to me with a fully baked arrangement of what they want, and I'm really just the scribe and drafting. But I really try to meet them where they are and meet what their needs are. So, Chris, you had a question, or we're gonna say something?
When you have bring in the court reporter, we don't do that yet. Are you coordinating a meeting with the parties and attorneys and everybody signing at the same time?
Yes, and actually, we're using Deb Wood, and she's amazing, and we have her appear over Zoom. So it's so quick and easy for her. And when sometimes the other lawyer wants to be there, sometimes they're like, just send me a list of your questions ahead of time, and they're really vanilla. And so I will send the list of questions. Sometimes they want to be there and they'll appear over Zoom too. Sometimes they don't. It's really just preference. Of course I will. I'll share anything. Just email me and I'll share it. Okay. So my goal is to create an agreement that works for my client. And their interests aren't always exclusively financial. A lot of times they want to start their marriage off together. Even if they want to protect all their assets, they don't want their spouse to feel like they're going to be screwed in the event that something happens. Pardon my language. So let's talk a little bit. Oh, did you have a question? Okay, about what can and can't be included in these documents. You cannot include things that are in violation of public policy or statute that imposes a criminal penalty. So that, most of the times I don't have people asking to include things like that. Every once in a while, I'll have people that want to do kind of haywire provisions, and I'm pretty much unanimously successful in dissuading them from doing that. Texas is a no-fault divorce state, meaning you can get divorced without proving that the other side is at fault. That is done for the safety of people in the state of Texas. So that a spouse wanting to get divorced doesn't have to prove that they're a victim of abuse or other issues. And so I am not a fan of including fault grounds and things that require those kinds of proof in the document. Like what?
Cheating?
Like cheating.
That something you could put in there?
Absolutely. And I have a client right now who is insisting on it. Both sides are, and we're doing it.
And you
And
outline proof, like what is proof?
well, so in Texas, we're about to get into biology lesson here, okay? So in Texas, adultery is one of our Texas Family Code statutory claims. Case law says that adultery is penis and vagina sex.
Okay.
Sure makes a limitation on what most people would consider adultery. So I'm not a fan of that. I won't use that word, okay? Like I may use it in my notes, but really what I'm gonna go out and do is use what our typical discovery language uses, discovery requests for the interrogatories, which talks about, I don't remember it off the top of my head, Chris, do y'all?
Like the emotional?
Yeah, it's like emotional, and it doesn't have to be just penis and vagina sex. It's all of it. It's the stuff that pretty much everybody would agree is adultery. And I use that language, and I typically say there has to be a finding of that by the fact finder. So, there is evidentiary proof required, but the case that I'm doing right now, the one that I'm working on right now, they want that provision in there, and they're both it's a later in life marriage. They both have kids that they want to protect their estate for, and they're both well off, and they are putting in $100,000 financial penalty if that's found by one and not both. If it's both, nobody pays anybody anything. If it's one, then the spouse committing adultery is going to be paying the other one $100,000 as part of the divorce settlement. Yes.
I'm gonna go down a rabbit hole here, but could you put also that spouse hires someone to have said affair for that person, you know what I mean?
Like a setup to get a clean vote?
Like, I don't even go so far as to put a provision in there saying, if you set this up, you're gonna give me an additional penalty.
You can contract anything that's not against the law in Texas, right? And so, yes, you could put that in. There. I would argue that they're still committing adultery. So even if they've been entrapped, they're still doing something, right? Like, so maybe, maybe they're still gonna have to have a penalty anyways, but these provisions are rare, 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 rare. I've done 3 of them in my career, probably, maybe not. Yes,
Have you done any provisions for like open marriages? Look at a case where the open marriage and everything was fine except for penis and vagina, but someone crossed that line and upon her just was like, all of it is, fine. So I heard that this was a little bit different than in case law.
so that's a really good question. I haven't had it in a premarital agreement. I have dealt with it in a postmarital agreement. Where the parties were polyamorous and both were like, you know what, we want to set up some clear boundaries. They really were using the document more as a financial boundary, and there wasn't any penalty there. But the amount of polyamory that is showing up in our divorce cases in the last 5 to 7 years is significant. My first 10 years of practice, I had maybe 3 polyamory cases or swinging cases. Now they're pretty much really common. I mean, they're just really common now. So it's become much more socially acceptable in the world, and people are choosing to go into those types of relationships eyes wide open. Plenty of times it works and plenty of times it doesn't, and we see the ones that don't. So but yeah, sometimes people do set up those arrangements. Yes, Amber.
One of my favorite trash television shows is 90 Day Fiance.
Yes, ma'am.
Laura and I texted about it at night, and the woman came from another country, and her husband has all the money, and they're doing a premarital, and she wanted in there that he gives her kids by 40 because he had kids already. She was 37.
Yes.
And I think he was just like, sure, whatever, but I mean, how can you guarantee that you can give somebody kids?
How can you guarantee that you could give somebody
She
kids?
was smiling on the camera going, hey, put it in the prenup for me, I'm happy.
And if he doesn't, what is the penalty would be my question. That's what I would tell him if he were my client. Great, put it in there. What is the consequence if it doesn't happen? Because most premarital agreements, everyone I've ever drafted in Texas, say that there's no damages. Like the only thing you can enforce is what is in the document and the division of the assets in the document. So a provision like that, unless there's damages, whoop-de-doo if he doesn't do it, right? I mean, what's the consequence might be?
In her head was, I don't have to, the prenup, doesn't stand if I don't get kids. Like it will know everything.
Well, I hope she had a lawyer because that's not how it works. Her spiritual advisor, I'm sure, knew all about the law, marital property law in her state. Yes.
So, what happens if 2 parties, one doesn't speak English really well? Do you get a translator?
Absolutely. That's only happened a couple of times. And if they refuse to translate, because most times they have a pretty passing level of English. If they refuse a translator, I'll usually get that documented in writing that even just an email. I offered them a translator, and then they didn't want it. Because that would be very good grounds, I would think, to be able to overturn one. Yes. The statute wasn't modified per se, but the case law just basically had a rein that touched everything. So yes, if that makes sense. So when Obergefell happened, it just literally trickled down to everything. So even though our documents, the statute says husband and wife, we don't follow any of that. The courts don't follow any of that. And I now write most of my documents spouse A, spouse B, because that's the inclusive way to do it. And so, so the statute hasn't changed. I don't foresee any statutes changing in Texas to that direction in my career. Hopefully they will, but I doubt it. But it doesn't matter because our courts uphold them for same-sex spouses all the time. Okay, the other things that cannot be included is adversely affecting the right to child support. So you can't put in a prenuptial agreement that if we get divorced, nobody has to pay anybody any child support. You can do spousal support. We'll get to that in a minute, but you cannot do child support. What you can put in there is that you have to pay more than what the guideline amount of child support is, or that you have to create a trust for the child, or you have to pay for the child's college education, things like that. Anything that is not adverse to the financial benefits or the best interest of the child, you can elevate financial requirements to children, but you can't produce that. You also can't agree to, possession schedules for kids that don't exist yet.
Your future children.
Yeah, I mean, I have people ask that. Can we put in there that if we ever have kids and we get divorced, we're doing a 50-50 schedule? And no, you can't do that. You can't do
If they had kids.
that. No, because the determination of the best interest of the child is at that moment in time. And the agreements are typically created prior to. Now, let's say we're doing a marital property agreement, like a post-nup agreement, okay? Let's say Texas does not have trial separation or legal separation, but let's say we want to effectuate a legal separation in Texas. The way we do that is with a postnuptial agreement and a suit affecting the parent-child relationship. And that's the way we sort of create what other states call legal separation. Texas does not have legal separation because we have such a short cooling off period here of 60 days, whereas in most states it's a year. So
We got things to do, people.
yeah, these people got to get remarried. They can't be waiting around for a year. So we kind of cobble together with other legal permissible documents, a legal separation agreement, and a suit affecting the parent-child relationship is a suit that's filed with the court. It is just the child portion of the divorce, not the property. And so that agreement and is done when people are trying to do a legal separation, but don't want to actually file for divorce yet. I've seen that happen times when one spouse is going to move away and take a job someplace else. Yes.
So it's written in there that both parents have 50-50 physical custody of the child. It can be set up or it can be set up where there's no money exchanging.
So in a suit affecting the parent-child relationship, which is a legal proceeding, parents can agree to 50-50 possession in that. We don't put possession schedules in premarital or postnuptial agreements. In that agreement, there is no statutory guidance as to how to calculate child support if you're doing a 50-50 schedule. And so I think it varies very widely by county as to what the judges are doing. I will say the trend that I see, and family law paralegals chime in if you disagree with me, is that they really look at, if you're doing a 50-50 schedule, they look at what is the respective income of the spouses or the parents. And if one spouse significantly out earns the other, they're probably going to be paying guideline child support, even if it's a 50-50 schedule. The difference between Texas's standard possession order and a 50-50 schedule is 4 weeknights a month. So they're not dramatically different. And we know for the standard possession order that the guideline child support is presumed to be in the best interest. Yes.
I think it's also important to note as there's a cap with child support, because some parents make over the 9,200, so that usually is a little bit easier to swallow. But of course, everybody's like, oh, we're gonna be 50-50, we're not gonna do child support. Why do that? I want to give you my money. It's not really the money, it's the child, right? So, but
And we often do, so I mediate a lot too, and we often do offset calculations, which is where we'll figure out in a 50-50 schedule what parent A is going to pay parent B, and what parent B would pay parent A, and calculate the difference and have the difference paid.
with a step down.
That's often too, yeah. In Travis County, we don't pay a lot of attention to the cap of 9,200 in my experience and with our clients, like, you know, I see child support above the guideline amounts frequently. You know, 3,000, 4,000, 5,000, depending, you know, especially if you have one person, one of the spouses or parents is earning 700,000-800,000 a year, which is not uncommon in our community. You know, it's an expensive, when one spouse earns 50 and the other one earns 800,000 a year, we've got to figure out something. And I think most of the lawyers that I've practiced with and in our community and most of the judges also. So.
All right, are you saying that you do an agreement above guideline or the judge orders above guideline?
Both.
for child
Both. Dang, dang is right. I know, Chris, I know you have worked with lawyers at Nokia. Are you still at Nokia? Okay, so they taught me how to plead to a court above guideline child support. And that's a whole nother topic we can talk about another time, but it absolutely happens in court. I heard of a lawyer a few months ago who did a case where his client had the standard possession order. He had dad, so it's stereotypical. Dad made $80,000 a year. Mom made, who had primary, $400,000 a year. He broke down the cost of living in Austin, and he got a judge to have mom, who was primary, pay child support to dad. That's the first time in Travis County I'd heard of that. I'm sure it's happened more, but you know, there's creative arguments to be had when there's a real big disparity in what the parents' income is.
Is that to give more money to the dad for the few days that he has with him?
I don't know what it was for, but what the thinking was behind it. But as we all know, to live in Travis County is expensive, and to live in Travis County with kids is really expensive. And so, you know, our judges are listening to those arguments. They understand. They live here too. They understand how expensive it is to live here, and they listen to those most of the time.
How would that necessarily differ? Like, why did they do it the child support route versus the spousal maintenance for the big disparity of income and earnings?
Good question. Because in Texas, spousal maintenance, you're only eligible for it if you have insufficient income to meet your minimum reasonable needs.
Okay, not the disparity.
Not just a disparity. And so nobody knows what minimum reasonable needs is, but it used to be kind of walking around knowledge, $30,000-$40,000. Would y'all agree? And so if you're earning above that, even if your spouse earns $1 million a year, you're not getting any. Yes.
The judge orders above guideline is going to appeal. I mean, that just seems like why bother with the statute if there's.
Because the statute is just a guideline. That's the key. It's just a guideline. It's just a start. It's a presumption and it's a guideline, but you can always deviate from guidelines. And Travis County judges do and have for 10 years probably. Williamson County will step out of the guideline amounts a little bit. Some of the judges there will. Sometimes Hayes does. Travis, it is a line that they step across whenever they want and frequently, because we have a lot of really high earners here, you know, a lot of really high earners.
Where are they at? Where the single ones at?
That's a whole nother CLE, like the matchmaker CLE. One of it, I don't know if y'all know Billy Powers. He's a lawyer that was in town that has been around for forever. He used to work for legal aid, and he used to have a Lonely Hearts Club Valentine's party where he would invite all his clients and all his friends' clients on Valentine's Day to come like mix and mingle. It was a fun entertainment. Okay, so things that can be included in premarital and postmarital agreements and that we typically do agree is what is everybody's rights going to be with regards to property. If it's their separate property, can it be affected by a standing order? Meaning, can they be limited in disposing of it or selling of it? We typically address that in premarital agreements. Characterization, is it something that under the law would be considered community property? but the parties are gonna agree that it's gonna be considered separate property. We put that in premarital agreements, postmarital agreements all the time. Interestingly, you cannot take separate property and make it community property in a premarital or postmarital agreement. That requires a separate agreement called a conversion agreement that has magic language that gets included in it. And so what you can do in a marital property agreement is make it separate to separate, but you can't go separate to community unless you do a conversion agreement, and those are pretty rare. Now you can commingle it and unintentionally make it community property. That happens all the time, but you can't intentionally make something that was separate to community.
Would commingling be, you own a separate property house and you rent it, but the rental income goes into your family bill paying account?
That is step one of
Okay.
that, okay? The question is, can you untangle it? And well, first of all, does do those pennies, we go down to the penny, does the penny, because the account is not the asset, it's the penny in the account.
Mhm.
Does that penny still exist at the time of divorce? And if so, can it be traced back? But remember, unless the premarital agreement says otherwise, income from separate property is community. So the income from that rental property would be community property unless you say otherwise. And when people set up premarital and postmarital agreements, I give them all kinds of instructions about, don't mix your money up unless you do it intentionally in a joint account. Even if people are setting up the scheme where everything's going to be separate, we always include a provision. I always include a provision about them having a joint account together, because they almost certainly will. They almost certainly will buy an asset, like a titled asset, like real estate or a car together. So I include provisions in the agreement regarding those, like they're going to own it in proportion to their contributions, or sometimes they say, we don't care how we contribute to it. We want to own it 50-50. That makes me a little nervous because in my experience, people sign these agreements, put them in a drawer, totally forget about them, and then don't follow the rules to keep everything protected. And then at the time of divorce, will be a month or two down the road and somebody will go, oh, we had a premarital agreement. Do y'all need to know about that? Lawyers, do you need to know that we had a premarital agreement? We're like, yeah, we do. We do. So that can be a challenge, but that's why I personally prefer these schemes of setting everything up where everything's separate. And then if you have a disparity in the net worth of that spouses, to do some sort of lump sum payment as opposed to a division of community assets, because that makes the agreement, that makes it much easier for them to effectuate it during their marriage, when nobody is following whatever some paper signed that they signed before they got married, Other things that we often put in there is if they get divorced and if there is community as property, how is it going to be divided and what percentage? So there's a lot of things that are put in premarital agreements for the sole purpose of reducing the things that people can argue about at the time of divorce, such as who's going to pay whose attorney's fees. We put in there often that each pays their own, or that the moneyed spouse will provide a flat amount, 10, 20, whatever $1,000 to the other side. And we put flat specific amounts in there so that they have less to argue. A lot of times we'll put in there that they're not going to have the opportunity to discuss a disproportionate division, which happens frequently in Texas. That would, disproportionate means something different than 50-50. We're going to put in there that any joint assets or community assets will be divided 50-50. It's one less thing they can argue about. Texas has this really fascinating and messy concept called reimbursement claims. That's in the packet that I handed out to you. And a reimbursement claim, there's 3 marital estates typically in a marriage. Spouse A's separate estate, spouse B's separate estate, and the community estate. During the marriage, when one of those estates pays certain expenses on behalf of the other estate, that can create a reimbursement claim. Those reimbursement claims only exist in the event the parties divorce. So it could have happened 15 years ago, but it only arises at the time of divorce, not during the marriage. So that creates a lot of stuff for people to argue. So a lot of times, pretty much all the time, we'll waive those reimbursement claims in these agreements so that they have, again, one less thing to argue. A lot of times we'll waive spousal maintenance or temporary support or things like that in these agreements. There is no case law yet that has upheld that waiving spousal maintenance is something we can do, but everybody does it, and I've never seen a judge not enforce that contractual agreement. Let's see, what else? I've mentioned attorney's fees. A lot of times I'll put in alimony provisions too. If we're keeping everything separate, but we have a significant disparity, I frequently see people wanting to do some sort of alimony or lump sum payment, depending on the years of marriage. And that's a scheme that I do recommend because you know exactly how much you're going to pay or receive under that arrangement. Whereas opposed to paying lawyers hundreds of thousands of dollars to try and dig up and see what there is.
You know how long you have to hang in there.
It depends, like usually they're graduated. The one that I was mentioning or referring to where they created their own scheme, despite mine and the other lawyers, like strong encouragement to not do that. It was a very, very large net estate that my client had. And if the wife divorced him on day 2 of the marriage, she would have been paid $2 million. And so I did not like that arrangement and he did not care.
Is that guy single?
I don't know. I don't know. Boy, I'll tell you from the experience I had with the 2 of them, he probably is. And so, and one of we mentioned earlier that I do collaborative divorce. Our office does collaborative divorce, and we do prenups collaboratively as well. That means that both parties have lawyers and we're working on focusing on their interests and their goals together, as opposed to kind of the arm wrestling dynamic. All right, so when people come to me, what's the timing on these? And that's kind of an important thing I want to talk about. Don't reach out, if your clients are coming to you saying, you know, I think I might want a prenup. What do you think I should do? Don't have them wait until 3 weeks before the wedding to reach out to a lawyer about it. I personally will not take a case if it's within 30 days of the wedding. Other lawyers will, I will not. I just don't feel good about doing that. I don't have the bandwidth, frankly, to do that. And so I really encourage people to go talk to a lawyer. If they think they might want one, go talk to a lawyer before they propose. At a minimum, go talk to a lawyer and start the conversation 3 months before the wedding. I really like the document papered and signed and done before the invitations go out. I've never personally, knock on wood, had one blow up that invitations did not go out, but I have had ones that were being negotiated and the parties decided to call off the marriage before the wedding date was set. And, you know, that's a difficult situation, but also I know both of them were probably happier that they figured it out than much further down the road. Yes.
How do you address debt going into a marriage with a premarital agreement? Like student loans are big now. So if one party has student loans and the other does not, how do you address the payment of that? And then, you know, whether the party is reimbursed, you know, if they pay it out of their community and state.
Very good question. So loan debt that is accrued prior to the marriage is that party's separate debt. So it's not community. But of course, everybody uses community property to pay those debts. One of the very few exceptions to a valid reimbursement claim, student loans. And so even if those are paid off during the marriage, the community cannot require to be reimbursed for those during the marriage. One of the schemes that I do a lot of times with a moneyed spouse and a non-moneyed spouse who has a lot of debt or a lot of loans is the non-moneyed spouse wants all their loans and debts paid off. And I think that's a great scheme. And so a lot of times we'll put in there that after so many years of marriage, all the debt that they came into the wedding, into the marriage with, the moneyed spouse will pay off, particularly student loans and things like that.
During the marriage or if they get a divorce?
Either way. Either way. It's just kind of whatever works for them. But that, because if you think about it, and I represent a lot of non-moneyed spouses too, and a lot of times they're typically a wife, going to be wife. And, you know, she may be giving up what was the beginning of a potentially lucrative career path to support the spouse, their soon-to-be spouse, and then very possibly staying home, having kids, and giving up a lot of career growth opportunity. And if that person gives up all that career growth opportunity and ends up divorced down the road with no community estate and all this debt that they came in the marriage with, that can be devastating, just devastating. And so I typically like to see that if we have a less moneyed spouse coming into the marriage, that there is some sort of exit plan for them, that they're going to be okay as they transition to being single after the divorce. And I have yet to have a client that was a moneyed spouse not agree with that. You know, they are really agreeable as they're planning the wedding. They're a lot less agreeable at the time of divorce. So that's a very common structure. Any other questions? Okay. So in the handout that I hope y'all have, if not, we can email it. I go through an outline of what is marital property in Texas. We've gone through a lot of that. And I go through also, for example, what Texas considers a just and right division of the estate. I kind of touched on that a few minutes ago. You know, a lot of people think, well, it's 50-50, it's 50-50. Lawyers get paid a lot of money to argue that it is or is not 50-50. And I would say that is a very significant expenditure at the time of divorce, is people arguing over that. Different factors that can contribute to whether it's going to be divided equally or some other way is a disparity in the earning capacities of the people, how much separate property somebody has, and if the other side doesn't have any. What is the size of the community estate? Is it a $50,000 estate or is it a $5 million estate? Are they gonna, is the spouse who's getting half gonna get a lot of money or a little money? Different factors can swing that. For a long time, we would see the biggest swings we would see would be kind of a 60-40. The last few years, out of our more recent judges we have on the bench, I've seen a couple 70-30s come out of it. And so that can be a really, really powerful factor for people to agree to just do a 50-50 or some other type of very specific arrangement in their marital property agreement. A lot of times we'll put in the marital property agreement that they're going to, you know, not worry about fault grounds because everything is set out and the financial arrangement is set out as to what the division of the assets is going to be. Fault grounds essentially impact the division of the estate. And so there's the only benefit that one would get out of filing fault grounds if they can't get a different division of the estate would just be that feeling of being able to file fault grounds. So yes.
So I have a question, when going back to that provision about like adultery, could you have as a damages, if either party commits adultery, we can use that as a fault ground and then therefore nullifying this division and let the court decide if it's disproportionate? Could you put that in the provision?
You can play chutes and ladders in these agreements however you want. If you write it cleanly, yes, you can say if A, then B, and if B plus C, then Z. Like we can do it however we want. The key is the person interpreting the agreement going to follow what you wrote? So in my office, when I do chutes and ladders type of provisions, I always have other lawyers in my firm look them over to make sure, are you reading this the same way I intended it to be written? Because if you're not reading it that way, and you and I have been working together for 10 years, I can pretty much bet that the third party judge or arbitrator is not going to read it the same way I intended it. And so very often in situations like that, I'll include hypotheticals in the agreement. Like, here's an example of what we mean by this. Talking about judges or arbitrators, I always encourage my clients to put an arbitration provision in these agreements. We always include a choice of law. So we always include that these agreements are going to be interpreted under Texas law at the time they're signed. Sometimes people change it to at the time they get divorced, but I always keep it at the time the agreement is signed, because I don't know what the law is going to be in the future. I haven't perfected that ability yet. So we all know what the law is now when we're signing it, so we can predict that. So we live in a very mobile society. People move out of state all the time. And so all the states in the United States honor each other's states' premarital agreements. I can't say that for other countries. So I always tell my clients, if you're considering moving out of the country, come back, let's talk, let's get you hooked up with a lawyer to make sure if there's any hoops we need to jump through to make your agreement enforceable in another country, we can do that. But in the United States, we don't really have to worry about that. But you know, if my guys move, I represent the husband and they're moving to California and they may get divorced in California later down the road. I don't want a California judge who has no experience in Texas family law interpreting this agreement. I want it to be a family law specialist. So in all of my agreements, I require that the arbitrator be board certified in family law in Texas, and also that they have been certified as an arbitrator by the American Academy of Matrimonial Lawyers, which is like the creme de la creme of arbitrators. So that way, you know that you're giving your client the best chance of having the agreement interpreted correctly. All right, I see that I'm close to out of time. So I want to just hit on a few other things to make sure and then answer any questions that you guys have. We talked a little bit earlier about spousal maintenance, and a lot of folks assume that Texas has a powerful alimony law like other states do. We don't really. It's just started maybe 18 years ago, I think, about 18 to 20 years ago. And at that point in time, it was for a maximum of 3 years and like $2,500 or something. And again, the threshold back then was you had insufficient resources to meet your minimum reasonable needs, which is a pretty difficult barrier to get across. Because, you know, minimum wage earns you what, like low 20s now, and you just need to be able to earn a little bit of minimum wage to be able to beat that barrier. But now Texas has expanded our spousal maintenance laws, and so the statute allows for higher amounts to be paid up to $5,000 and then up to 10 years, and in very very rare instances for lifetime maintenance. But those are very, very difficult and very, very, very rare. But a lot of people will put in these agreements that they're either going to waive spousal maintenance completely, or we're going to put in that it's alimony, meaning it's contractual and it's absolutely going to be paid. I think that is a great tool in these agreements, especially where everything's staying separate, for the non-moneyed spouse to have some transitional income as they transition back into being single. And that's one of my favorite tools to use in that situation, in addition to kind of a lump sum to allow them to start over. That is the highlights of what I wanted to talk to you guys about. I've included in my packet the intake form that we use in our office for these things. I always want to know, when is their ceremony? I mean, Hannah asked that question first. When are you getting married? Because if we can't meet the timeline, then we want to refer them down the road. I want to know, do they have children? Because that can complicate these arrangements too. If they're coming into the marriage with children, it adds an extra level of things that we want to consider and be aware of. I want to know, do they own any property together right now? And you'll see on the last section of the handout is the information that we send out to ask them, what are all your assets and liabilities? What do you own separately? What do you own jointly? Do you have a trust interest? Did your parents set up a trust for you? Tons of people don't know if that's the case, because people typically don't tell their children their estate plan and they find out upon their death. But if, you know, we want to protect any trust interest that they do have. Trusts are not community property or separate property. They're trust property, which adds an extra level of complication in the event of a divorce, because some case law in Texas has said that undistributed income in a trust could potentially be considered community property or community asset. It's a murky area of the law. So anytime there's murky areas of the law, I always want to draft really clear agreements around those spaces. So, but we go through, you know, what are your retirement accounts? What are your financial accounts? Do you own any real estate? Do you have any cryptocurrency? Do you have any, you know, art or significant things like musical instruments? Do you have a business interest? Business interests can be really important things to consider in in marital property agreements as well, because it's very common that a spouse that became a really high moneyed spouse did so by owning their own business. And depending on how many people they own that business with, or how that is structured, if they are still managing it themselves, that creates a really ripe opportunity for them to shelter and hide income in a separate property business and not distribute it. And so we want to be mindful of that too, because we don't want to create, again, another really expensive situation where a bunch of lawyers are having to peel back a business and look at bank accounts for the last 20 years to see, you know, is there any community in there? Is there not? So folks that have businesses, it's also really important for them to have really clear boundaries and understandings of what's going to be community and what's going to be separate. You asked earlier about debts. So without a premarital agreement, debts that were acquired prior to the marriage are separate property. Most premarital agreements that I see all say that debts created solely in one person's name during the marriage are also that person's separate property. Most creditors will follow that and honor that agreement. There's one exception, two exceptions. One exception is the IRS. They don't care if you have a premarital agreement, they're going to get their taxes. And the second exception is certain medical debts. And medical creditor is going to be able to get to property to satisfy their debt, sometimes across the boundaries that the parties have contracted with in their marital property. So, yes, I don't have anything else. So if y'all have questions, I'm happy to answer them.
So my question is about conflicting contracts or documents. Wills aren't contracts, but if you have a prenup that you promised your new wife the world, and then you later do some estate planning that maybe contradicts that, the premarital agreement would be the one would be coming into play, or?
Great question. I define it like this. If I have a cup of pencils, the premarital agreement is agreed to by both people, can only be changed in writing, signed by both people. And it defines which pencils are going to go in which pencil cup, right? If this is my pencil cup and this is my spouse's pencil cup, we each individually create our own estate plans or wills, and we decide upon our death where those pencils go. I may decide that all my pencils are just going to go right back into my spouse's cup. In that situation, the estate plan completely controls, and I can change my estate plan at any time and don't have to tell my spouse about it.
Right.
I can make all my pencils go to Hannah. I can make my pencils go anywhere. Okay. But what I can't change by that will or that estate planner is what pencils are community and what pencils are separate, as we agreed in the marital property.
Okay.
So the marital property agreement categorizes the assets.
Okay.
Your estate plan says, where do they go upon your death?
What about your governing documents for your business? Like if you and your shareholders, you have some bylaws that say you can never, a spouse can never get part of the ownership or something, and then there's a divorce where the spouse is trying to get into that. Would the governing documents prevent that?
Good question. And we have conflicting case law in Texas on that right now. And those are called buy-sell agreements, for example, is a very common thing. And you know, lots of buy-sell agreements value the business interests very low, right? Because they want the partners to be able to easily buy in and out. There's some Court of Appeals cases that say, yeah, we don't care how you're valuing it for community property purposes. We're going to value it however we want, whatever the fair market value is. So that's a murky space. And we don't know the answer to that, but again, whatever the parties contractually agree to in the premarital agreement controls. So you can specifically acknowledge that they're
We'll
going
never
to,
have any interest in that company.
right,
Or
right.
we'll see what we can do.
right, right. Yes,
Slightly off topic, common law marriage. I'm in a case right now where he died, there's no paper, wasn't anything. And she was always considered girlfriend until she hired a lawyer. And suddenly we're common law, right? But isn't there something required on the state of Texas? You can't do a few things. Yeah, you can't
there's
swap-
3 elements to be considered common law. You have to live together. There's no length of time requirement. It can be 1 day. You have to have a present intent to be husband and wife. So they have to have intended to be husband and wife. And the third is you have to hold yourself out to others as husband and wife, or husband and husband, wife and wife. I'm sorry about that, as spouses. That holding out is the big element that we gather all the evidence on. Did they file joint tax returns? Did they put each other on health insurance as spouses or domestic partners? If domestic partners, that's prima facie evidence that they are not married. What other evidence is there? Is there filling out of loan applications as a married couple? Is there Christmas cards that say, to you, my wife? What is the evidence out there that can show that? And that's not an uncommon situation, but it's going to have to be proven to meet those
Is the
elements.
burden of proof for her?
Yes, yes. And there's a presumption, again, not definitive, but a presumption that if you do not seek a divorce within 2 years of ceasing to reside together, that you were never married. There is no common law divorce. So if you ring the bell, meeting all 3 of those elements at the same time, then you're common law married. But there is no common law divorce, but it's only the 2 spouses, one or the other, that's going to be arguing that they're common law married. There's no independent third party who's roaming the world, coming out going, well, y'all are common law married and you're common law married. So thank you all for having me.
That was awesome. Thank you.
In lieu of a speaker, we have CAPA